Okay, Shannon, put us on the record.
Alrighty then.
Okay, we are back on the Bullwinkle matter. Let's see. Who's your next witness?
Mr. Berger, Tim Berger.
And that's, I assume, who's sitting with you right now.
That's correct, Your Honor.
I've got another person on screen, but I don't know who that is. Is she involved in this case, gentlemen?
That's not my witness, but it could be. I'm not who that. I'm not sure.
No, I'm supposed. I put in ID meeting for Dennis Conant. Is the attorney?
Yeah, you're in Judge LaFlamme's courtroom, and Mr. Conant does not have anything on my calendar today. You might want to give him a call.
Okay, thank you so much.
You're welcome. Have a good day, ma'am.
You too.
Your Honor, we will be joined by Christina Pete, the CPA, when she maybe around 9. She's going to join us, just so when you see her face pop up, you'll know who it is.
Fair enough. Sir, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Please state your full name.
Timothy Gene Ruger.
And then spell the last name.
Brugger.
I'm sorry, I didn't see that.
Brugger, Brugger.
Yes, sir.
That I had.
If you could get him a little closer to the microphone, he's a little too far away, I think.
Maybe I speak too soft.
Yeah, and if you could keep your voice up, that would help too. Go ahead, Mr. Miller.
Mr. Berger, what is your relationship at the Michigan Pipe?
I own the Traverse City Yard.
And how long have you owned the Traverse City Yard?
April Fool's Day 2001.
So, have you sat on the board of Michigan Pipe Co.?
Yes, I've been a board member since then.
Can you tell me what management fees are?
They are a fee to each yard for invoicing to help facilitate the cost of paid invoices, accounts receivable, accounts payable, insurances, and such.
Are management fees, have they been paid since you've been an owner?
Yes, sir.
Did the management fee structure change in roughly 2013 to a graduated management fee?
I believe they did, yes.
And do you remember who requested that change?
It was Nathan Bullwinkle.
And did you hear Mr. Bullwinkle's testimony regarding the how they came up with the percentages? I'm gonna just withdraw that. Do you remember how you came up with the amount of charge?
I see he's in the meeting,
That.
but he's not on my docket this
But
morning.
do you know what was based on? Was it based on the actual anticipated cost, or what was it based on?
Oh, it was based on if a yard did, say, $5 million in sales invoicing, that they would be charged a little bit less. And if they did even more than that, say I think it was $8 million, they'd be charged even a lesser extent. Yeah.
And what are the costs at the Michigan Pipe Co. that management fees cover?
Oh, it covers the employees, the rent, the copy machines, the fax machines, and all of the equipment, insurances for the employees, that type of thing.
Have you,
Mr. Miller, can I stop you for just a minute?
yes, you may.
I want to make sure I'm clear on this. When you say management fees cover insurance, wages for employees, benefits, et cetera, you're referring to the employees who actually work directly for Michigan Pipe Company and not the employees who are being leased out to the several shareholder corporations?
That's correct, sir.
All right, thank you. Go ahead, Mr. Miller.
Are you familiar with the concept of rebates?
Oh, yeah, yes.
Were rebates around when you bought into it?
Yes, sir.
And could you explain to me, and I'm speaking in the time when you bought into it, which was, I believe, 2001.
Yes, sir.
Could you explain what rebates, your understanding of rebates in 2001?
Yeah, they, if us as a group purchased X amount of dollars from a particular vendor, then he would give you a incentive to purchase more from him and in financial rebates at the end of the year, or sometimes they were paid quarterly.
Was that an added function of Michigan Pipe Code that combined its shareholder purchasing power?
Yes, they typically figured out what branch got how much money. Yes.
Did you listen? Were you here when Linda Prater testified?
Yes, sir, I was.
And did you hear her testimony regarding the fact that the most accurate way back then was to get breakdown calculations from each vendor, and then you knew how to distribute them?
Yes.
Have you experienced receiving the rebates that way since 2001 up till 2015?
Yes.
Do you have any criticism of that process?
No, it seemed to work fine. I had a level of trust with the corporate office, and they would do a proper job.
Do you recall when the embassy group was brought on?
Yes.
Could you just, in your own words, what is the embassy group?
They are a large company that kind of, oh gosh, how would you say, get a lot of companies like us to buy from particular vendors, so those manufacturers can sell more product to a select group of companies like us, and by doing so, they would, the individual companies like myself, distributors, would get a little bit of rebate at the end of the year or quarterly. So
Is Embassy a nationwide company?
I believe they are, yes.
Embassy Embassy has a rebate that we talked about called a silent rebate. Did you have silent rebates prior to Embassy?
No, sir.
Embassy has a rebate that there's been a lot of testimony called bogey. Did you have bogey rebates prior to Embassy?
No, sir.
Prior to Embassy, though, you had vendors giving breakdowns based on the individual agreement with Michigan Pipe Code. Is that fair?
That's correct.
That's all the questions that I had, Your Honor.
Cross-examination, Mr. McCann.
Yes, Your Honor. We could bring up Exhibit 38. I believe I have somebody who can do that for me.
Are you referring to his deposition, counsel?
Yes, his deposition 38. And page 10 of that. Okay, and Mr. Bruger, do you recall giving a deposition back on, let's see, this would have been July 16th of 2018 regarding this case?
Yes, sir.
Okay. And do you recall being asked a question about the graduated pay system. When we was questioning you at the top, you said, oh, a percentage, 2%, 3% sometimes. On line 5, you said, well, I think it was 1 to 3. Question 1 to 3. And you said, I didn't pay a lot of attention to it, really. Right, when you started in 2001, were there rebates distributed at that time? Yes, I believe there were. You recall giving that answer?
Yeah.
And then on page 11, actually, going back to page 10, line 21, going into page 11, do you recall being asked the question, did any of the branches receive rebates that were sent to them and then they had to put it back into Michigan Pipe Company? Your answer, I don't believe so. I question, not that you're aware of anyway. And you said no. Okay, and those rebates, was there ever a change in the way they were distributed, or were they distributed the same way throughout your time? I believe they were always distributed the same way. I think you recall giving those answers?
Well, it's right here in writing, so I guess I do.
And you indicate that you started back in 2001 with Michigan Pipe, correct?
Yes, sir.
I have no other questions for this witness, Your Honor.
Any redirect, Mr. Miller?
No, Your Honor.
Okay, thank you, Mr. Bruger.
You.
Are you able to contact his office?
Your Honor, now, well, I'll wait. Are you ready to move forward?
Yeah, I just had a couple people waiting in the waiting room that aren't on my docket this morning. I'm gonna take just a moment to find out what they're doing there.
Okay, very good.
Good morning, Dennis.
Good morning, Your Honor.
I see you're in my waiting room, but I don't have you on my docket this morning.
Well, we should be there. We were going to take the default proofs on Walker versus Walker. It was a case in seeking injunctive relief on some real estate.
Yeah, I don't have a file. I don't have anything in front of me this morning. I had someone who was right here, right at 8:30, that she said she was looking for you. It was a black woman. I didn't catch her name.
Probably Deborah Walker.
I told her I didn't have anything on my calendar and that she should give you a call.
Okay. All right.
So I'm in the middle of a civil trial right now, and
Okay.
I think we're going to need to figure out what happened and probably renotice it.
Okay. We sent it out October 16th to the court with notice of hearing.
I don't doubt you, but I don't have it. I mean, if you want to wait around, I can have Peter track down the file for me, but you're going to be waiting a while. So I'll leave it
Well,
up
I
to
guess
you.
we can do that. I've got people in San Diego and Atlanta, so we can certainly do that, Judge.
All right, you might want to get a hold of each of those people and let them know that it might be a little while.
Okay. Well, they hopefully they're zooming in right now, but I will do that.
Okay.
Thanks, Judge.
All right. We're ready to resume on Vowinkle matter. Your next witness ready?
He's right here. It's Teresa Jaime.
Ms. Jaime, would you raise your right hand, please? That you do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name for the record and then spell it first and last.
Teresa Jaime, Teresa, last name Jaime.
Go ahead, Mr. Miller.
Ms. Jaime, what is your relationship with Michigan Pipe Co?
I am the secretary of the board.
Do you have any relationship with one of the shareholders of Michigan Pipe Co?
What do you mean?
Well, do you have a relationship with, there used to be five, now there's three shareholders, correct?
Yes,
Are you, have anything to do with,
I am one of the owners of the Saginaw
I
branch.
need to know the name of the case so you can.
you are a part owner of the Saginaw branch?
Correct.
And you're the secretary of the corporation.
Correct.
Have you ever been the chair?
Yes.
When was that, if you remember?
I don't remember.
What's your best estimate?
Probably, I think it maybe 2012 or 13. I'm not sure.
Do you remember the date that you first became involved with Michigan Pipe Co?
We became owners in 2012. I've been working for Michigan Pipe since 2006.
When you say we became owners, could you explain that to the court?
I am joint owners with Justin Jaime and Jonathan Jaime for the Saginaw branch.
And just for the sake of clarification, where did you get your interest from? Who owned it before you?
James Jaime.
So you've been involved since 2012?
Correct.
Do you know what management fees are?
Yes.
What are management fees?
It is an agreement between the shareholders to support the corporate office.
And it has, are you aware of who, let me just withdraw that. Has everyone paid their management fees through the second quarter of 2016?
No,
Who has not?
Michigan Pipe and Valve Lands.
And do you know what quarter they have not paid or what they have not paid?
It was the second quarter of 2016.
Other than the Lansing not paying the second quarter of 2016, every other member has paid all their obligations.
Correct.
I'm gonna just show you a couple documents. I have Exhibit 13 on the screen, which is an age receivables. Are you familiar with this document?
Yes.
Now, once a quarter goes by, and it's determined through that sliding scale, the sliding scale, is that put on the books of Michigan Pipe Co as an accounts receivable?
Yes, it is.
And so when Michigan Pipe Co receives money for the third quarter, or any quarter, it's counted as income to Michigan Pipe Co. Is that correct?
Yes.
Okay. Now, what software do you use, if you know, for this?
Peachtree
And Peachtree is
is an accounting, yes.
is an accounting software. Okay. And you see where it says MPVF?
Yes.
What does that refer to?
Michigan Pipe and Valve Plant.
Okay. Let's see if I can get this. Okay. Now, this age receivable says as of December 2016. So it's as of the end of the year in December. What does this document reflect with respect to Michigan Pipe and Co. and Valve Flint?
It represents what they owe to the corporate office for invoices that the corporate has paid on their behalf.
In this case, it's $7,300 and
Yes.
what can you read?
$6.01.
Okay. Now there's been some discussion about this. There's lots of negatives, and there's some of these dates that appear to occur after Michigan Pipe and Valve Flint left. Can you explain it?
Yeah, so when we put it on the books for Michigan Pipe Co., like the 816 BCN, that would be for the coverage for August, but it was paid in July. So we pay ahead of time So the credits would be for coverage of August.
So the credits are because they left and then the companies gave you a credit for those costs?
Correct.
Okay. What about some of the ones that are not credits, that are positives that occur? Like why you have a BCBS in July for $2,000 when they weren't there in July?
Right. Because we pay that in June ahead of time. So those were still for their employees. And then for the next billing cycle, they will have credits on their account,
Okay.
like on 8/16.
So the date on the left side, 7/16, that's not the date this was paid. That's the date you put it on as accounts receivable?
That's yes. That's the date that the coverage is for. So we paid 7/16 in June for July.
I know. So now I'm confused. So on July, you just testified that an entry here that says July 16th is for an invoice that you paid in June.
Correct.
And so what does July 16 represent? Is that,
That's the date that we put it on the receipt.
okay, I must have not spoken clearly because I thought that for a second. So this date is the date that you put it on the receivable. It's not the date the invoice to BCBS was paid.
Correct.
Okay. And now below that is the Michigan Pipe and Valve lines. Let's back this up. So this is treated as a regular invoice or a regular debt that Michigan Pipe and Valve Flint owes. Does the company actually invoice the Michigan Pipe and Valve Flint or any of its shareholders debts?
Yes.
Okay. So is it your testimony under oath that Michigan Pipe and Valve really, both in 16 and beyond, have received invoices of these dollar amounts depicting exactly what we're looking at here at this age receivable?
Yes.
Now, MPVL is Lansing, is that correct?
Correct.
And you see the $1,000, $100,000, $308 figure? That's the second quarter management?
Correct.
Okay, let me go to Exhibit 15. And Exhibit 15 is a sales summary. And then in the second page, it's a management fee summary. And you see the breakdown that we've been discussing up on the left corner.
Yeah.
And so that's the breakdown that each of the, what does that breakdown represent? I got to be careful. I like to lead and I have to ask better questions. So what does that breakdown represent?
It's a scale. So if a branch has $0 to $5 million in sale, they would pay 1.34%. And if they have between 5 million and 8 million, they have 1.15, and then over 8 million, they pay 1% of their sales for management fees.
And what do the management fees cover?
They cover all the expenses that come along with the corporate office.
Could you explain what types of expenses they are?
Employees' expense, rent, consumers, any sort of office supplies, things like that.
As an owner of Michigan Pipe and Valve Saginaw, is this a obligation?
Yes,
And why do you feel it's an obligation?
because we have agreed to pay these to support the corporate office so the corporate office can function and help us.
When you first became involved in 2012, was it a flat fee for all the entities or was it a graduated fee like this?
It was a flat fee at that time.
And do you know the circumstances of how it got changed from a flat fee to a graduated fee?
I believe Nathan Boldwinkle presented it to the board because his branch was having more sales than the rest of us. And so he proposed the sliding scale so we wouldn't have So he wouldn't have to pay as much in management fees if he had that much sales.
And so on the number right here, 100,033 that appears at the second quarter, does this come from applying this percentage structure to these sales?
Correct.
Okay, so it's basically a math operation.
Yes.
Is that the same number that we see when we look at the accounts receivable second quarter where you see the $100,000? That's the exact same number.
Yes.
So that's a plug-in from that.
Yep.
And this also indicates that he paid the first quarter, correct?
Yep.
Because if he hadn't paid the first quarter, it would be on here as of accounts receivable, correct?
That's correct.
And the testimony regarding the dates on these is the same for Michigan Pipe and Valve Lansing as it was for Flint, that these reflect the dates they were entered onto the books, not the date the company wrote the check to the insurance or whomever.
Right.
And again, this indicates that Michigan Pipe and Valve Lansing owes Michigan Pipe Co. $117,702.18. Have they been invoiced for this amount of money?
Yes.
Have you ever received anything from them saying that there's an inaccuracy on this invoice? This invoice, to be perfectly honest, has been standard. There's nothing unusual about this age receivable from any age receivable since you've been involved in 2012. Is that a fair statement?
Yes, that's a fair statement.
Are you aware of any time when the management fees were not enough?
Yes.
Could you explain your answer?
We have had a few years, I think 2014 was one of the years that we did fall short with our management fees.
So management fees, when Nate proposed the change to graduation, was there a detailed discussion amongst the board members and the individual shareholder representatives as to what actually is needed to pay for the operation of Michigan Pipe Co?
Yeah, I'm sure there was yes, there was a discussion regarding.
Were you involved in that discussion?
Yeah.
So you really spent some effort with Mr. Vollwinkle involved to try to come up with.
Object to the leading question, Your Honor.
Yeah, Mr. Miller, you really need to work a lot harder at asking non-leading questions. Objection is sustained.
So could you describe what you recall about those discussions pertaining to why you came up with these particular amounts?
I don't know the details on why we came up with those particular amounts, but I know that we had a discussion probably at a board meeting regarding what the expenses are and what the projected sales would be for that particular year. And but I don't recall exactly why we chose those numbers.
Well, do you recall the goal of the company in coming up with in the discussions and coming up with these particular percentages?
The goal was to just have enough money in the account management fees to run the corporate office.
And do you recall any goal other than that?
No.
That's all the questions I have, Your Honor.
Questions, Mr. McCann?
Thank you, Your Honor. Ms. Jaime, can you tell me about your education and experience?
I have a bachelor's of management from Northwood University. I have worked for Michigan Pipe since 2006. Before that, I worked for 7 years at an engineering firm.
And what have you done for Michigan Pipe specifically?
Michigan Pipe and Valve Saginaw.
Yes.
I'm the office manager and one of the owners.
And how long have you been in that position? As
I've been the office manager since 2006, when I came on, and an owner since 2012.
You indicated in your testimony that Michigan Pipe and Valve Lansing had not paid its second quarter, correct?
Yes,
They did pay their first quarter.
yes.
Can we pull up Exhibit 13, the aged receivables again, please? Okay, going back down, I believe it was right in this area here, where you indicated that these, one of the payments from, I don't know, might have been Blue Cross and Blue Shield for 7/16, it's when it posts, and you indicated that that was paid in June for July, correct?
From Pipeco, not Michigan Pipe and Valve Lansing.
Right.
Michigan Pipeco paid it, correct?
Right, but they paid you, your testimony was that they paid in June for July.
Correct, we pay it in advance.
Okay. You also talked about the sliding scale. If we can bring up Exhibit 15. And you indicated, I believe, that this was proposed, the sliding scale was proposed by Mr. Volwinkle. You indicated that it was so that he could pay less. Isn't it true that he actually paid more because he made more money than anybody else? More of his money went to management fees than the other yards.
It's based on sales. So if you sell more, then you pay a little bit more. But with the sliding scale, if you have more sales, then you pay a less of a percentage to management fees.
I understand that, but if your volume is high enough, the reason for the sliding scale is so there won't be too much additional money in Michigan Pipe Company. Isn't that correct?
Correct.
Okay. And the fact that when your volume is to a certain extent, even if you're down to 1%, you're still putting more money in than the other companies are if your volume's high enough, correct?
Not necessarily. I mean,
well, if you look at the math, the Michigan Pipe Company in the second quarter brought in over $8 million. And if you look at the billing there for $100,308.33, it certainly suggests that they brought in more than anybody else. Correct?
yes, because their sales were higher. Correct.
Right. I have no further questions, Your Honor.
So, Ms. Heap, I have a couple questions. If you could leave that exhibit up, please.
Give it up.
My understanding from earlier testimony is that the goal of the 5 shareholder companies for Michigan's pipe company was that the fees paid in to cover management fees would actually equal the cost of managing Michigan Pipe Co.
Correct.
Is that correct?
Yes.
So that if during the course of the year, as a result of high sales, more money was paid in based on this scale than what it cost to actually manage Michigan Pipe Co., that at the end of the year was a reckoning, and those overpaid management fees were then credited back to each of the 5 shareholders.
We always had discussion on that at the end of the year, yes.
You didn't want to leave an excessive amount of money on the books with Michigan Pipe Company for one reason, to avoid Michigan Pipe Company having to pay taxes on those funds.
Correct.
So at the end of each year, if there was, well, let me back up. So you said in 2014 it was actually under. Was there a discussion at the end of 2014 as to how much each of the 5 shareholders would have to kick in to make sure that Michigan Pipe Company's management expenses were covered?
Correct.
And similarly, in years when the amount paid in exceeded, there was a discussion about making sure that excess management fees were refunded to the 5 individual shareholder companies.
Correct.
Was there a particular mechanism for doing that when the amount was over?
No, I mean, we didn't have a particular formula or anything. We consulted with Tina Heap, with our accountant, and we also discussed among ourselves if there was anything extra that we wanted to pay for, like any equipment, or we've thrown around buying a building for the corporate office instead of renting. So we just had that discussion every year, depending on how much was there and how much we wanted to leave in.
Right, but once you decided that a sum of money, whatever it is, let's say in 2015, once you decided whatever extra you wanted to spend at Michigan Pipe Company, there was $100,000 left over, hypothetically. How would it be determined to redistribute that $100,000 to the 5 shareholders? Was there a formula?
Oh, yes. Yeah. So it was based on what you put into the corporate office. So it was based on the percentages of sales, just like the management fees. Going in, it was the same coming out.
So it was a pro rata return.
Correct.
So for the particular quarter that we've been talking about, the second quarter of 2016, would you agree that Michigan Pipe of Lansing, that $8 million in sales was an unusually large quarter of sales for any of the companies, even including Lansing?
Yeah, it was a really good sales quarter. Correct.
And because the management expenses of Michigan Pipe Company do not go up proportionally to the volume of sales, wouldn't that mean that come the end of the year, Michigan Lansing would be entitled to at least a partial rebate or refund of some of those fees?
Perhaps, yeah.
All right, that's all I had. Thank you.
Thanks.
Any redirect or
Yes, Your
follow-up based
Honor.
on my questions?
Yes, Your Honor, because I do think there's some misunderstanding. And could you describe could you get rid of the thing, Mr.? Could you describe for this court what happens when you have additional sales? Does that create some additional work for corporate?
For sure.
I think, could you give this court a flavor of what has to be done as sales go up? What sort of things does the corporate do because of the sales?
There's additional invoices that need to be processed. There's additional payables that need to be processed. There's additional, all the office supplies, all of, overtime for the employees, things like that that will go up definitely if there's more sales.
Who does lien claims?
The corporate office.
I'm sorry, Mr. Miller, I did not hear that question. I heard her answer, so
Okay.
she obviously heard it.
Yeah, well, it's the mask. We're trying to be safe here, and I forget sometimes to take it off. I'm sorry. I'm gonna just, it hasn't really been put into evidence, and so I'm trying to get you to testify for this court what sort of things the corporate does as sales increases. It's not, there's additional work, and I want you to explain it to the court.
I thought she already testified to that. I heard her. There's additional invoicing. There's whatever has to happen to process the additional invoicing that comes from having more sales. But you had asked a specific question that she answered yes to.
Well,
I didn't know the question.
I was asking her to expound on that, and I specifically asked about claim of liens, but I wanted to give her
You just said it again. You just said it. I didn't understand what you just said.
Okay.
Something of
Lien
claims?
Claim of lien.
Lien claims. Thank you.
Would you explain what a lien claim is?
So we invoice the customers and ship material, and if they don't pay, then we have to file liens or paperwork to try to get that money from the customers. And corporate does that as well. So if you have that many sales, more often than not, some customers won't pay, and the more they don't pay, the more liens and files that we have to file. So that also is additional.
Once Michigan Pipe and Valve Lansing and Michigan Pipe and Valve Flint quit, did the expenses automatically end on June 30th?
No.
Could you explain to the court what sort of expenses continued on behalf of these two entities into the third quarter? I had to drive 2.5 hours every day just to help out down there. We've had to terminate all their employees, talk to all the insurance companies. There's other, things like that we had to do to terminate their companies and their employees, as well as try to get all information that they were asking for as well. I have no further questions.
Further questions, Mr. McCann?
You're on mute.
Your microphone's muted.
Sorry about that. Okay, Ms. Jaime, wouldn't these extra costs you're talking about, be shown in the operating expenses?
Not directly. I mean, it would be overtime for the employees. It would be, time, pretty much.
Overtime and those types of things wouldn't show up in the operating expenses?
Yes, they will. They would.
It will show up. Okay.
Yes, they would.
So isn't it true that the cost to operate Michigan Pipe Company don't go up incrementally based on the amount of sales in a dramatic way? I mean, you're talking about more invoices, more office supplies. These are not substantial comparatively to the amount of money that's brought in by that volume of increased sales. Isn't that correct?
I'm going to object that as argumentative when we start using dramatic and words like that. It appears to me he's arguing.
Objection's overruled. It's a fair question. This is cross-examination.
I mean, I can't give you the facts and figures of how much more, but yes, volume of invoices and payables and work that it has to do with, sending everything out and paying all our vendors and things like that does go up, definitely, with the sales. Because if you have $1 million in sales, you may have 100 invoices. You have $8 million in sales, you may have 20 invoices or 100 invoices or whatever. It's more. I can't tell you exactly what the facts and figures are of dramatic, but it does go up.
So if Michigan Pipes Company's expenses are covered, if they're brought down to a zero balance, in other words, the expenses for the first 6 months of 2016 are covered and brought down to a zero balance, then you would be able to compute mathematically what the percentage of refund of potential expenses would be, wouldn't you?
No, because some expenses are yearly. They're not just within 6 months. So we don't normally do a 6 month check and balance of if we have enough. We usually do that at the end to see if we have enough, and then at that point we would have a discussion.
So those, you're saying that you should be able to bill for expenses after a company separates from Michigan Pipe Company. They should continue to be billed after they've sold their interest.
If it has to do with their company, correct?
It has to do with their company in what sense?
If the time or the expense that we're putting forth in that last 6 months for their company, even if they left, if we're still doing work for them, and there is an expense at the end of the year, like insurance doesn't do by 6 months. It goes by, like, we have an audit at the end of the year. So that would also be, we would have to figure that out.
Aren't you in fact doing work for Michigan Pipe Company? You're no longer doing work for Michigan Pipe and Valve. You're closing out accounts that you need to close out as the result of a change in the business structure. Correct?
I understand the question.
As a function of Michigan Pipe Company, you are closing out you're changing. There's a change in the nature of the way the business is operated when two of the Michigan Pipe and Valve entities leave, and you're basically closing out the way you're operating Michigan Pipe Company. That is not something that you would be billing those entities for after they've left and separated.
Is there a question?
I don't understand.
I'm asking
You can ask a question.
So just put a question mark at the end of that. Is that true?
I mean, if two branches leave, then yes, we do their work, we close them out. If that's your question, yes.
I have no further questions, Your Honor.
So, Ms. Jaime, was there an effort made at the end of 2016 to calculate each company's share of management expense, underage or overage?
We talked about it, but at that time we were kind of in talks of litigation of this, so we kind of just left everything that we had. We didn't really have big discussions because we didn't want to do anything that would, we didn't want to use money that maybe wasn't ours.
Was any attempt made to try to calculate what that might be?
Not that I know of.
Thank you.
No questions, Your Honor.
Heidi? Any further questions of this witness?
No, Your Honor.
All right, we need to take a pause. In your case, I've got some other folks waiting. I'll take that matter up.
Your Honor, may I inquire if Ms. Heap is in your waiting room?
She is.
Okay, good, thank you.
All right, and I'm going to let her in now. And I'm going to leave you folks in, but if you could just mute your microphones so we're not picking up any background noise. Okay, somebody's got a YouTube playing in the background. If you could mute it, please. Mr. Conant,
Yes.
I had Peter retrieve the file for me. There is nothing in the file besides the complaint and the return of service. There's no entry of default. There's no motion for default judgment. There's nothing entered on base. I cannot act on your file this morning.
Okay.
I
very good,
apologize
Judge.
if something got delayed down in the clerk's office, but there's nothing I can do with that matter today.
Okay, yeah, well, we mailed it out on the 16th of October, but the judgment of default request, entry and notice of hearing, but things happen. I understand. So we'll see what we can do to retrieve it.
Okay,
Thanks, Judge. Have a good one.
you're welcome. Okay, I have, let's see. Matter of Baker versus Columbia Medical Center. Counsel, state your appearances, please.
Good morning, Your Honor. This is John Turk on behalf of the plaintiff.
Loretta Subi on behalf of Dr. Keelhorn and Columbia Medical Center.
And good morning, Your Honor. Stephanie Charisny on behalf of Dr. Monfett, Henry Ford, and Independent Emergency Physicians.
Turk is spelled Turck. Subi is spelled Subhi. Charisny is spelled Karisny.
Thank you.
You're welcome. Okay, so this is a motion regarding a request that I deem request to admit as admitted or any alternative order amended responses. And I'm not sure, it's a defense motion, but I'm not sure which counsel filed the motion.
Yes, Your Honor, this is Loretta Subi for Dr. Keelhorn and Columbia Medical Center, and we are the ones that filed the motion.
So I've read the motion, and basically what you're doing is asking the plaintiff to admit that there's nothing in the medical records documenting a certain situation. Is that correct?
That's correct, Your Honor. That's what we asked, that there's no evidence, which means in the medical records, et cetera, that he was ever diagnosed with a certain diagnosis. We asked him to admit things about a specific report that was attached to the request to admit. And the only response was denied because the plaintiff, Mr. Baker, doesn't remember. That's not an appropriate response. Plaintiff's response to my motion was late, and plaintiff's response to my motion was not even responsive to the arguments made in my motion. But you're right, there's two choices here. Either you can deem them admitted, or you can give him some time to amend his answers. And if he's going to amend his answers, he also needs to complete the interrogatories appropriately, which were attached to our request to admit. And if you've read my brief, I don't have anything more to say than what's in there.
Thank you. Mr. Turk?
Judge, the responses were not untimely. They were filed, mailed to the court for filing. They were provided to defense counsel. On that basis, the motion is clearly inaccurate and wrong.
I never argued that.
As well, she just said maybe I misunderstood, Loretta. I thought you had said the responses were untimely.
No, I never said
the
that.
response to the motion.
Oh, I'm
was
sorry,
untimely.
Judge. I misunderstood. I apologize. You know, as to the medical records, they are what they are. You know, it's the classic, the document speaks for itself. Now, if Ms. Subi would like Mr. Baker to review the records and admit that there are words not in them, that Ms. Subi claims are not in them, then I can have him do that. I suppose I probably should have asked him to do that even before we spent our time together this morning preparing for the motion. But Mr. Baker has said in his responses to the request to admit, this is what I remember happening. That it's not documented does not necessarily mean it did not happen. Ms. Subi is, of course, entitled to argue that if it doesn't show up in the medical records, it didn't happen. I don't begrudge her that. opportunity. But Mr. Baker, by his own terms, is allowed to say, this is my recollection, my remembrance of that particular visit. So if the court wants him to, if the easiest solution is to simply say, Mr. Baker, we want you to go through these particular medical records that Ms. Subi provides and admit that this phrase or these words do not appear in them, then I'll do that. And we can be done with it and go on to our next thing.
Your Honor, this has
Why do
nothing,
Hold on. Counsel, you've got the records. You see that that's not in there. Why do you have to have your client go through and read that when you yourself, as his attorney, know that it's not in there?
Because, Judge, when my client reads those requests to admit, what he perceives is the argument, the ultimate conclusion, or the ultimate argument from the defense. If the words, XYZ or the letters XYZ are not in there, that means it didn't happen at the visit. I agree with Ms. Subi that those specific words are not in the request, but I don't want Mr. Baker's response, and Mr. Baker certainly doesn't want his response to that to be deemed as some admission that that didn't happen at the visit. That's why he went to such lengths in those responses to say, over and above even probably what was asked for, this is what I remember happening.
Give me just a moment.
can I respond, Your Honor?
Give me a moment. I'm looking at the responses.
Excuse me. There is one other thing, Judge. I don't mean to interrupt you, and I apologize, but I'd like to say.
Go ahead, Mr. Turk.
As to, for example, as to request to admit number 6, it asks Mr. Baker to admit that there is no evidence that he had a heart murmur prior to the December 18, 2000.
Counsel, I read that. I know exactly what you're going to say.
All right. And
that clearly he can deny.
Sure.
His recollection of the visit would be evidence. It's not very strong evidence, but at least it's evidence. I would agree with that. I mean, that's why I took the time to read this. As I look at the requests, number 1, admit that in 2005 you have no evidence that Anthony Baker was ever diagnosed with mitral valve prolapse. That ought to be pretty easy for the plaintiff to either admit or deny. Either a doctor told you have mitral valve prolapse or he didn't. How could that be anything other than admission or denial? Request number 2, admit the adult stress echocardiogram does not make a diagnosis of mitral valve prolapse. That ought to be easy. Either it does or it doesn't. That's simple. 3, admit that the adult stress echocardiogram done on 12605 indicates there's no visualization of mitral valve prolapse. If that's what it indicates, it's either an admit or a deny. I mean, there doesn't need to be any explanation to that. It's clear. Number 4, admit that if mitral valve prolapse was present on 12605, it would have been visualized. Now, I get that perhaps an expert might testify that, well, there are times when it gets missed on a adult stress echocardiogram, but your client wouldn't know that. Your expert would certainly know that. And I would think, based on your communication with your expert, you ought to be able to either admit or deny that. Number 5, admit that the cardiac evaluation done in 05 never revealed a heart murmur. That's a little harder because that may involve a communication with the doctor that your client claims never made it into the medical record. I get that that might be a little harder to answer yes or no to. And then the 6th one we've already talked about. Again, if he remembers it, he could certainly deny it. But then he's going to have to answer the interrogatories related to the denial. So I'm going to give you 14 days to file amended answers to these requests to admit. If your answer is a denial or anything other than an unequivocal admission, you need to answer the interrogatories.
I understand.
Same time period.
I understand.
All right. Ms. Subi, you'll prepare that order?
Yes, I will, Your Honor.
Thank you, counsel.
Thank you.
Day.
Take care. Be
Thanks.
well.
Okay, we are back on Bullwinkle. And Ms. Heap, I believe, is present.
I don't see her yet.
She's logged in. She might have her screen darkened. Ms. Heap, can you hear us? All right, your voice was a little faint. Are you able to make a video connection with us, please?
Yes, I am. I can see you.
Yeah, all I see is a black screen. I know we had you earlier. I don't know what happened to it. Let's try logging out and logging back in. So I just kicked her out. Let's see when she logs back in if we've got we had a good connection earlier.
Well, and she's, Your Honor, I believe in the same connection that Tom Ryan was on yesterday. So it should, she might be at home. I thought she was going in, but I don't know. So I thought she was on the same connection. While we're waiting, Your Honor, can we discuss closing argument issue?
Of course.
I just wonder what this is my first trial here. Do you like to have them done right after proofs orally? Do you like to have them by briefs? Like some of the judges up here seem to like us to do closings through briefing. And I just didn't know. We never talked about it. I didn't know what you prefer.
Normally in a bench trial where there's a lot of conflicting proofs, I ask for proposed findings of fact and conclusions of law separately numbered by both counsel. I think I understand this case well enough that I don't need to put you through that. If you're ready to proceed with oral closing arguments this morning, I'm happy to do it that way.
That's fine with
Any
me.
preference?
No, I just,
sorry.
the court's preference is fine with me.
Yeah,
We lawyers always like to write things, but
If it's a complicated case and a complicated record, I definitely prefer proposed findings of fact and conclusions of law. I don't think this case is that complicated. I think I've understood the testimony, and I am content to move forward with oral closing arguments. And after your arguments, if I'm ready to rule, I'm prepared to rule today.
okay.
Thank you, Judge.
All right, if somebody could communicate with Ms. Heap, I kicked her out and asked her to re-log in. Oh, here she is. Hold on.
There we go.
Hey.
We don't have an audio. There we go. All right, much better. I don't know what happened before, but I'm glad we went through that exercise. You are Ms. Heap?
How do I increase the volume right here?
Can you hear me, ma'am?
Yes, I can. Thank you.
Okay, very good. Could you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please, you can put your hand down. State your full name, spell your last.
Christina Marie Heap. Last name spelled H-E-A-P.
Go ahead, Mr. Miller.
Good morning, Ms. Heath. What do you do? What's your profession?
I'm a certified public accountant.
And is Michigan Pipe Co. one of your clients?
They are, yes.
Is Michigan Pipe Co. the branches of Michigan Pipe Co. the Lansing, Saginaw, and Traverse City and Jackson, are they your clients as well?
Yes, they are.
You do CPA work for Lansing and Flint when they were members of Michigan Pipe Co.
Yes,
And are you currently a CPA for Nate Bowinkle and Mike Deneen?
I am.
So you're basically everyone's CPA.
Correct.
I'm going to show an exhibit, and I'm going to ask you if you recall it. Let me pull it up. Can you see that on your screen, Ms. Heap?
Yes, I can.
Okay. Are you familiar with this summary, this exhibit?
Yes. Yes.
Can you describe for me what this is?
This is a summary of the rebates that were due to the various yards as of 12/31/2016.
And when was this prepared?
It was in August, during a board meeting, they had called and wanted a summarization of the dollars that were in the checking account, those that represented rebates.
Up in the upper left-hand corner, I'm just asking because it says a date, looks like 8/31, but it says 2/08.
Yeah, it should have been
What was-
2018.
I'm sorry. What was the correct year?
2018,
So 18. So this was prepared in 2018.
yes.
As far as you know, does this summary incorporate all the data that was available when it was prepared?
Yes,
You see the column that has Flint and Lansing on it.
I do, yes.
And this summary would purport to say that for rebate fees, and okay, let me ask the question. I've been having trouble, I tend to leave. What does this summary say is owed to Lansing in rebates?
It would be there at the bottom, 150,548.02. Oh, for
And
that,
would
for,
be,
for
that's
Lansing?
Flint, right?
Yeah,
Okay.
Lansing, I'm sorry, it would be 269,632.26.
And this doesn't have anything like management fees taken out of it, does it?
No.
Okay.
That's
Now, you see
all
a
rebates.
column. You see a column that says Pipe Co. Towards the left, the second column.
I do, yes.
And I think the first entry there is 24,715.69. Can you describe that column for me?
That would have been the bogeys that were allocable to Michigan Pipe Co.
Now, this is an issue that probably is significant to the court. Those numbers that appear in the Pipe Co. column, were those included on a tax return for Michigan Pipe Co.?
Yes, but probably not 2016.
At the point in time when you concluded these were attributable, you then included them as income for Michigan Pipe Co.
Question, Your Honor.
I agree, it's leading. Rephrase your question.
When was, do you know when this was included in taxes?
No, not without looking at the tax returns.
Okay, and why was it not included in 16, but yet included at a later date?
Well, with the rebate summaries or the rebates being calculated very close towards the end of the year, and some of the divisiveness maybe that was going on, they weren't picked up in income.
Now, the numbers that you mentioned a minute ago, down below Flint and Lansing, 150, 548.02 for Flint, for example, that amount has not been included on an income tax return for Michigan Pipe Co., has it?
That is correct.
Is it typical that you include these rebates on the tax return for the entity in the year in which they're received by that entity?
That would be correct.
Okay. You testified at your deposition regarding a concept called clearing account. Could you describe what a clearing account is?
Well, the clearing account was set up by Linda Prater, and as rebates came in, cash was debited and the clearing account was credited. And then as the rebates went out, cash was credited and the clearing account was debited. So it's an in and out account.
I'm going to change, I'm going to get rid of this. When you look at the expenses of a company such as Michigan Pipe Co., is it appropriate or fair, in your opinion, to look at 1 or 2 quarters as opposed to all 4 quarters? And why?
I'm sorry, Bob. I could you say that again?
Part of this case, we're analyzing the expenses and costs for Michigan Pipe Co., and we've looked at the first 2 quarters. And I'm asking you, in your role as an accountant, what your view is on how to look at the expenses of a company via an income summary when you're only looking at 2 quarters versus 4 quarters.
You'd have to have all 4 quarters, especially in something like Michigan Pipe Co., because their income is management fees And that varies based upon the sale of pipe and related valve materials, etc. And so January, February, and March aren't real high sale months. And so there wouldn't be a lot of management fees paid, but they still have ongoing expenses.
Do you have personal knowledge of whether there's annual bills that come in the fourth quarter of Michigan Pipe Co. that may be applied to costs from the first quarter or two?
Yes.
The concept came up regarding a retained earnings. And could you explain to this court what retained earnings are?
Retained earnings is the net income or the net losses that have been retained in a corporation throughout its life.
So what financial document does retained earnings show up on?
Shows up on the balance sheet in the equity section.
Is retained earnings directly related to cash on hand?
No, because you could have $5,000 of depreciation expense. That's a reduction of net income, but you didn't really pay for depreciation. It's a bookkeeping entry.
So why is retained earnings included on a tax return?
To establish basis, and it's page 5 of the tax return. The last page of the tax return has the balance sheet per books, and so that's why it sits out there.
So an income tax return such as Michigan Pipe Co. requires the balance sheet. Is that what you're testifying to?
Yes, the last page of the formal 1120 has a balance sheet section.
So is retained earnings reflective of the entire life of the entity?
Sure, yes, it is.
Okay. You mentioned management fees. What are management fees?
Management fees are paid to cover the costs at Michigan Pipe Co. of those employees.
How long have you been the CPA for Michigan Pipe Co.? Or how long have you been working on Michigan Pipe Co.'s tax returns?
Michigan Pipe Co. Since its inception in 1999, I believe.
And can I ask what sort of accounting work you do as in audited versus non-audited?
We don't do any audits. We don't do any reviews. Michigan Pipe Co. is a tax return.
And when you don't do any, so you strike that. Is there an accounting phrase to describe your role with Michigan Pipe Co.?
My role?
Yeah, like a bonding company's role.
We're their certified public accountant.
And you do compiled tax returns?
Not for Michigan Pipe Co., no.
How would you describe the type of tax return you do?
We just do a standard 1120. They're a C corporation.
Since the inception, have they always had management fees?
Yes.
Have you been involved in coming up with what the management fee percentage should be?
No.
Do you know how management fees are obtained?
Obtained?
Yeah, if you could describe for the court what management fees are and how they're paid.
Management fees cover the costs of Michigan Pipe Co. and they're paid either quarterly or monthly. I believe they're paid quarterly.
Who pays the management fees?
The various yards that utilize the services of Michigan Pipe Co.
I'm gonna bring up a document. I had to take a look at it. Have you ever seen, Ms. Heath, this document before?
Yes,
Could you describe for me what this document is?
it's the management fees for 2016 that the 5 yards paid.
Did you have anything to do with preparing this document?
No,
Does this reflect paid or what they were charged? If you know.
this would be paid.
Okay, well, let me show you another document. This is probably more up your alley. Do you know what this document is?
Aged receivables
Did you know where this document comes from?
from Michigan Pipe Co's Peachtree accounting system.
I mean, what is Peachtree accounting system?
It's where how they keep their books.
Is Peachtree a accounting system that bond company uses with its clients and customers?
That we use.
Yeah. Did you require they use Peachtree, or did they do that independently? If you know.
Oh, they did that independently.
Okay. I keep using bond company, and I may be
Yeah.
I may need to explain this. Who do you work for as an employee?
I work for Bond and Company.
So Bond and Company is the CPA firm that represents these entities, and you are the CPA. Is that correct?
Correct.
So are you involved with the age receivables at all? Are you familiar with this documentation?
I'm not involved with it, no. I'm familiar with the documentation.
You are?
Yes, I don't prepare it.
Okay. Do you prepare any invoices?
No.
I'm going to show you the entry for MPVL Lansing. Do you understand that represents Lansing?
Correct.
You see this entry here where it says second quarter management 100,308.
Yes.
What does that reflect to you? What does that mean to you?
That would be the second quarter management fee charged to Michigan Pipe Lansing.
Would this indicate that it was still outstanding, or would this indicate that it's paid?
This would indicate that it's still outstanding.
Do you have any personal knowledge of whether Lansing has paid the second quarter management fee or not?
I don't have any personal knowledge that they have or have not paid it.
Okay. How do you treat management fees with respect to Michigan Pipe Co? How are they reflected on the books?
Taxable income.
So to Michigan, strike that. Can you describe the types of expenses that the corporation has and what these management fees were designed to pay for?
Health insurance, employee costs, rent, utilities, standard expenses.
Are you aware of a formula that the company uses if there's excess management fees at the end of the year of what they're going to do with those excess management fees?
They would refund a portion of them.
And what would they, if you know how they make that decision?
Well, precedent always was that back at that point in time, tax rates on the first 50,000 of taxable income were taxed at 15%. And so it made sense to leave some funds in the yard. None of the owners had that low of, leave some funds in Michigan Pipe Co. None of the owners were in a tax bracket like that. And after 2008, and and they were all in workout. They didn't want to have a line of credit that they'd have to personally guarantee. And so they decided that they would accumulate cash.
And sometimes would the board decide to either, so that, back that up. So the decision to accumulate or refund, was that a board decision?
Yes, board decision.
All right, thank you, Ms. Heath. That's all the questions that I have.
Questions, Mr. McCann?
Yes, please, Your Honor. Ms. Heap, if we could go back, well, actually, I'd like to look at Exhibit 42 here first.
Would you like me to bring that up, Mr. McCann?
I think I've got some, you don't have it? Which one is it? 42, it's the last one. Protected.
Yeah, the retention.
If you need it, let me know.
Thank you. Okay, this is the summary of rebates that you were referring to before. Is that correct?
Yes.
Okay. And I believe you first indicated that this represents dollars in the checking account. Is that correct?
Yes, a portion, correct.
And with regard to the rebates shown to Flint and Lansing, those do not include bogey or silent rebates in those numbers of the 150 and the 269. Is that correct?
That's correct. Yes, it is.
All right. And as you indicated, no management fees were taken out for the second quarter in the total to Lansing, but also the management fees that were put in by Flint, there's been no credits for extra management fees in that figure, correct? It doesn't reflect any management fee credit or anything.
That is correct.
With regard to the retained earnings, you can drop that one down for me. The retained earnings, you indicated that those are throughout the life of the corporation, that and that's put in a separate category from other cash. Is that right?
Retained earnings doesn't have anything to do with cash. It's just an accumulation of net income and or losses since inception of the company.
All right. And there appear to be $167,000 or so in the account on December 31st, 2016. You recall that? Does that sound approximately correct?
Yeah, I do recall that being the figure.
You also testified that it was the practice to keep $50,000 or less in the account at the end of the year. And all of the previous members of Michigan Pipe Company who testified have indicated that management fees at the end of the year, excess put in, was refunded to the individual Michigan Pipe and Valve entities. Is that correct? And that's based on the percentage of sales, correct?
Correct.
The management fees go in based on the percentage of sales.
Correct.
And then they're redistributed to the Michigan Pipe and Valve entity based on what they put in if there's excess.
Yes, but the first part of the question that you asked had said we tried to keep 50,000 or less in the checking account. That's not correct, because the 50,000 builds over time. You try to keep 50,000 of taxable income. And so if I had 130,000 in my checking account at 12/31/15, and I wanted to keep taxable income between 35 to 50, then I'd have another 50 accumulate.
So you show an additional 50 or less each year.
Yes,
Okay.
correct.
Is it true that Michigan Pipe and Valve was an entity from the start of Michigan Pipe Company, nearly from the beginning? Michigan Pipe and Valve Lansing
Michigan Pipe and Valve Lansing was what? I'm sorry.
was one of the original Michigan Pipe and Valve companies.
Oh, yes, yes.
Michigan Pipe Company started, as well as Michigan Pipe and Valve Flint, correct?
Correct.
Okay. And so those retained earnings that were accumulated over time, a portion of that was money that was put in by Michigan Pipe and Valve Flint and Michigan Pipe and Valve Lansing, correct?
Correct.
So if the companies each owned 20% share, the amount of retained earnings would theoretically be 20% to each of the 5 Michigan Pipe and Valves that they would be entitled to. Is that correct?
I don't think that's entirely correct.
How would you calculate it?
Part of the retained earnings that were out there at 12/31/16 and the retained earnings of the 167,000 that you're speaking of, that assumes that, number one, the management fees are all paid, because remember that 167 is really accrual basis. It's book retained earnings. And so that assumes that these management fees are collected because that's income. So part of that.
I would give you that. The management fees, everything would have to be taken care of. But once the balance is all paid, then the retained earnings would be the property of the owners of the individual stockholders of Michigan Pipe Company, correct?
I would object, Your Honor. There's nothing that says she's an expert in the legal aspects of stock ownership or ownership of retained earnings. However, if she has a CPA opinion on that's fine. But she is not a business lawyer.
That's all I'm asking her is for her CPA opinion, Your Honor.
Go ahead.
Can you state the question again, Mr. McCann?
Yeah, I'm just asking you if those monies that would be left over, the retained earnings, from your understanding, who would own that money?
Michigan Pipe Co.
Michigan Pipe Company. And presumably the stockholders, the 5 stockholders or board members of Michigan Pipe Company, correct? The 5 entities that own Michigan Pipe Company?
Yes, they would own it.
Yes. Also, just with regard to, you said checking account. Is there only one checking account for Michigan Pipe Company?
There is one checking account, yes.
Thank you. No further questions.
Redirect, Mr. Miller?
I have no questions, Your Honor. Thank you, Ms. Heath.
Thank you.
Ms. Heath,
Yes.
before you go,
Yes.
could we bring up the exhibit 42 again, please?
Sure.
So Ms. Heath, your understanding is this is a document that was prepared by someone employed by Michigan Pipe Company?
This document?
Yes.
No, I prepared this based on information obtained from Justin Jaime.
I got you. Is this an Excel spreadsheet?
It is.
The column under Pipe Company, I think you testified, your understanding those were bogey rebates. Have you have you heard of a silent rebate as well?
I've heard of them.
Do you
Yes.
know if this column under Pipeco includes both silent and bogey rebates paid by pipe vendors?
It does, yes.
And for the time periods in question, looks like fourth quarter 2015 and 2016. Do you know if this reflects all of the silent and bogey rebates received by Michigan Pipe Company for those time periods?
Yes, it does.
And no portion of silent or I just lost the term, bogey rebates have been allocated to any of the individual companies?
No.
Is that correct?
That is correct.
Okay. Do you know if any attempt has been made to try to allocate those funds?
I do not know.
That's not something you were asked to do?
No.
Thank you. That's all I had. If there are follow-up questions based on mine, counsel, you're free to ask them.
I am finished. I have no further questions. Thank you, Your Honor.
I just briefly, Your Honor.
Go ahead.
Yeah. Can we bring that document back up again, please? And so, Ms. Heap, you're saying, according to the judge's question, you don't know if there's been a distribution with regard to these rebates, the 65,000 in bogey rebates that's listed there, plus the fourth quarter embassy rebates?
Do I know if there's been a distribution to the yards?
Yes.
Any specific yards?
Well, the remaining 3 yards, Jackson, Traverse City, and Saginaw.
65,000 would not have been distributed to any of the yards because they always stayed in Pipeco.
I'm sorry, okay. So Pipeco declared that?
They declared in 2017 they had income from the bogeys that were left in Michigan Pipeco. I'm not certain on 2016 without digging out the files and looking. So I can't answer that.
There's been testimony that the 2015 bogey rebates were distributed. So those were distributed, correct?
To the yards?
Yes.
To my knowledge, they weren't.
Or to Pipeco?
They're in the Pipeco column, so they stayed in Pipeco.
I see. Okay, thank you. No further questions.
May Ms. Heap be excused, counsel?
Yes.
Yes,
Thank
Your Honor.
you again, Ms. Heap.
Thank you, Ms. Heap. Have a good day.
Thank you, you too.
Okay, so does that complete the defendant's proofs, Mr. Miller?
Yes, it does, Your Honor.
Any rebuttal, Mr. McCann?
No, Your Honor.
All right, the proofs are closed. Court is ready to entertain closing arguments, but we're going to take about a 15-minute break here. I'll leave the Zoom meeting open, but we're going to go off the record, and we'll see you back here, about 25 minutes to 11.
Thank you, Your Honor.
Thank you.
Got all my neglect stuff.
Nice. What's the hearings on Tuesday, the DISP hearings? I saw those on the docket for, I think that was Tuesday, like Tuesday afternoon. Yeah. What? I just don't remember.
It's a trial slash dispositional hearing, so it's like a termination hearing.
Okay.
So you want to take it from that time here on.
I just don't remember seeing that designation.
Trial afternoon, my stuff out. No. Oh, man.
Yeah, I think it's the first box. It says not entitled.
You know, some of this internet slang cracks me up. It's never what I think it is, and then I'm like, whoa, okay, well, that's not what I thought it was.
I did. Nice. What time do you usually go down there?
I'm trying to get over a little bit earlier because the first 10 people there,
Probably more. Yeah.
you don't want to stand around and watch everybody all play.
Then you usually play till like 1:30.
But I changed my schedule back to accommodate basketball. So now I do not start court until 2 o'clock.
Okay.
Mondays, Wednesdays, and Fridays. I don't, an hour and a half should be enough. But,
Yeah, that's I mean, if you're playing that whole time, that's a long time to play.
no, I mean,
Oh, okay. I see.
shower, get up and then go back downstairs. Yeah, so an hour and a half is kind of tight. 2 hours is really good. I can play as long as I want.
Yeah, press for time.
You know,
Yeah, she is. Yep. Okay.
okay, Shannon, you can put us back on the record.
Alrighty?
Okay, we are ready for closing arguments. Mr. McCann?
Thank you, Your Honor. Your Honor, as the court pointed out, we are relying on an oral contract created through tradition and by the course of business, the way it was operated with that business for a period going back to the mid-1990s. We have also put forth our theory that there was an express contract as well, based on agency through our proxy, Michael Deneen, with the Embassy Group. So actually the proxy was Michigan Pipe Company, but Michael Deneen was the representative. So we're also have the theory that there was an express contract in addition. I'm not going to get into too much detail, Judge. I know that you listened to the testimony and understood it, but I would like to highlight a few things with regard to.
Let me stop you for just a minute. I see a couple people in my waiting room. Do either of you recognize the names Kendall Asbenson or Haas Murhai?
No, Your Honor.
Okay. I'm not going to worry about them. If they had something to do with your case and you wanted them in, I was going to give you that opportunity.
Thank you.
We'll just let them sit there. Pardon the interruption. Go ahead, Mr. McCann.
Thank you, Judge. With regard to the testimony of both Mr. Putro and Mr. Thomas Ryan, they both were founding members of Michigan Pipe and Valve Lansing and also Michigan Pipe and Valve Jackson. They indicated that the sole purpose of Michigan Pipe was to combine the administrative functions of the individual Michigan Pipe and Valve companies. They also indicated that always by tradition from the beginning, when rebates were earned at the time purchases were made from the vendors, and we heard repetition of that from pretty much everybody who testified. With regard to Mike Deneen, he talked about his history with Michigan Pipe Company and the camaraderie between the individual pipe and valve holders. He also took us through management fees and the way they work as a percentage of gross sales. And he talked about the sliding scale of 1 to 1.34%. And if you earn over $5 million, you qualify for the 1% that was brought into use prior to Embassy. And indicated that the reason for doing that was to ensure that there wasn't a large excess of money that needed to be redistributed, so the yards would have more money to work. With regard to rebates, same thing. The history of rebates was that they're earned at the time a vendor was paid. He testified to being with Embassy, to being contacted by Embassy Group. Once he was contacted, the board sent Justin Jaime and Mr. Deneen to Chicago. They found out more about it, brought it back to the board meeting on January 8th of 2015. Mr. Deneen signed as a proxy for Michigan Pipe Company as a representative to make Michigan Pipe Company its proxy. The reason they did that is importantly because Michigan Pipe and Valve Lansing and Michigan Pipe and Valve Flint were the only two with enough sales to qualify to be members of the Embassy Group. So in order to benefit the other Michigan Pipe and Valve companies, they came up with the solution of making Michigan Pipe Company a proxy. And so it was voted upon to enter the Embassy Group to achieve better rebates. Mike Deneen was the representative who signed the contract. And the next witness that we heard from after Mike was Linda Prater. And Linda was an important witness because she basically, by her testimony, did a brunt of the work. She had been there a long time, and she knew the way things operated. The defense has alleged that because nobody knew how to compute rebates, they were not able to be distributed. And I think that's contradicted by the testimony of Linda Prater. She indicates that she absolutely could have distributed the rebates by the accounts payable method. And she decided that she would prefer, the accountant in her prefers to be more precise. So she would rather compute it by having the shareholders or the board members contact the vendors and try and get actual breakdowns. That was not accomplished prior to her leaving, but she reiterated that she could have done the distribution based on accounts payable at any time. She also confirmed the way management fees operated. She indicated that that was a % of gross sales and that they were redistributed back to the individual Michigan pipe and valve companies at the end of the year, and any excess was redistributed. With regard to Mr. Vollwinkle's testimony, he gave us the same thing, that there was a history within the owners of the Michigan pipe and valve companies, that they got along very well. He talked about the rebate structure and management fees, confirming what Mr. Deneen said. The rebate structure had been proposed by him, but he indicated that the reason for it was so that there would be more money in the yards, so that they would be able to operate better and not have quite as much money to distribute back at the end of the year. He confirmed what was testified to about the Embassy Group and how they got into the Embassy Group. He talked about the bogey and silent rebates and indicated that those had been distributed in the 2015 had been distributed, but after that, or some, importantly, after Embassy came into being in January of 2015, some rebates, bogey, had been distributed. I believe testimony was that a silent was maybe used for a party. What Mr. Vollwinkle testified to was our Exhibit 39, which is a breakdown given to us in our discovery in 2019 from Bond & Company. It didn't come from Michigan Pipe Company. We waited a long time to get discovery. It wasn't until we had an order from this court that we were able to get what we needed to come up with an accurate breakdown of what the rebate should be. And our Exhibit 20 broke down very clearly what the rebates should be, what the management fee write-off should be. And the interesting thing is that it's virtually no different than the new and improved Exhibit 42 that they came up with. So our Exhibit 20 that we used, it's really it was, first of all, it was prepared by Justin Jaime. It was after the fact, so there shouldn't have been any discrepancies, and the actual numbers don't prove much in the way of discrepancy. They're very close. So in addition, Your Honor, I would bring up the testimony of Justin Jaime. I don't think that it conflicted with any of the testimony that was presented by the other witnesses. He also indicated that the history was that rebates were earned at the time a purchase was made from a vendor. He confirmed the rebate structure. Importantly, he confirmed that their bogey and silent rebates were eligible for distribution, and that there was some other form of them prior to the Embassy Group, but it was called something else. He referred to as Exhibit 42, but like I said, I don't believe that really changed anything. With regard to Tim Brugger and cross-examination, he admitted that rebates had pretty much been done the same way from the beginning. With Teresa Jaime, she talked about the management fees and admitted that they were based on a percentage of sales, and that they were refunded they were refunded to the yards that had earned them based on the percentage of sales. And Ms. Heap, the accountant for Bond & Company, it was important that she said that all monies were in one checking account per the accountant. So we know that their Michigan Pipe never created an escrow account, contrary to testimony of witnesses. Michigan Pipe Company did not have an escrow account. So all of the rebate money of the plaintiffs was being held in one place in their checking account for their use. Your Honor, there is a 20-year history here of both the oral contract that we referred to through tradition and through the way business had been conducted throughout that period. Their defense is that we didn't know how to compute rebates, or one of their large defenses is that, and therefore nobody knew how to compute rebates, therefore they were unable to distribute them. But testimony was that the accounts payable method would work when you don't have a vendor breakdown. Your Honor, our count of conversion is based on the fact that defendants received plaintiff's rebates. They withheld the excess amount of management fees. They held those rebates and management fees in their account. They did not create an escrow account to store our money. Conversion is defined as a distinct act of dominion wrongfully exerted over the perpetrator's property over the personal property of another, and defendant converted plaintiff's property to its own use. We believe that they have converted that money. We're requesting that statutory damages be ordered for conversion. We're requesting attorney fees. Based on the fact that this case has gone on for 4 years, we didn't get our discovery that we needed until 2019. My clients have borne incredible expense, $75,000 already just in expenses, and they have to pay attorney fees on top of that. Your Honor, plaintiffs are entitled to all rebates. We thank the court for its patience and its time, and we ask you to award us in the amount of $271,690.84 to MPV Lansing and $186,858.65 to Michigan Pipe and Valve Flint, along with attorney fees and statutory damages for conversion. Thank you very much, Your Honor.
Thank you. Mr. Miller.
Thank you, Your Honor. This case was presented as a breach of contract. As a matter of fact, the operative cause of action is breach of contract. Up until this trial, it was testified to that the breach of contract was a contract entered into in January of 2015. With this trial, through the testimony of Mr. Bowinkle pointed out, is no, really, the contract was entered into in 1999. So to the extent that we're talking about a contract that was entered into 1999, I'm on board with that. And I will acknowledge that there was a contract back then that we'll talk about. To the extent that they want to argue that there's this proxy contract, this is the first time this has ever come up. And there's no allegation about this proxy contract. However, as is pointed out in the evidence, the proxy contract, as testified by Mr. Deneen, occurred during his negotiation. And there's no documents to establish this agreement. There was some verbal conversation he had with the representatives of Embassy, according to Mr. Deneen. However, the Exhibit 11, the contract with Embassy, has a merger clause. It says very clearly, any oral or written agreement is now merged into this agreement. So anything regarding our relationship with Embassy is in that contract. The Embassy contract is a contract between Embassy Group and Michigan Pipe Co. There were no other agreements or meetings of the mind that occurred at that January meeting. There were some discussions about trying to come up with a formula to divvy up, and I'm using divvy up because that's the phrase that was in the board minutes, the Embassy money, but they never came to a meeting of the mind regarding post-Embassy distributions. However, to the extent that we're talking about the prior contract, of 1999 or thereabouts, I want to talk about that. But that is not something that I'm objecting or countering. You know, the testimony of all parties is that rebates are based on purchases, not sales, but purchases. And while this lawsuit really contains no direct data on purchases, there is only one document that the testimony says that is based on purchases, and that's 42. 42 might be very similar to other documents, but that's not the point. There's only one document that the testimony says was created directly as a result of the breakdown from the vendors in that arduous tax, and that's the document that was put together by Tina based on information from Justin Jaime, and that's Exhibit 42. That agreement, the one in the mid-90s, was that we're going to pay a rebate based on the relationship with the vendor, and the vendor prior to embassy would typically give us a breakdown. Once they hired embassy, that breakdown wasn't pro-offer. So Justin Jaime had to go back to each vendor and obtain a breakdown. That's reflected in Exhibit 42. And therefore, the rebates that Lansing and Flint are entitled to are reflected on that exhibit. To wit, Lansing is entitled to rebates of $269, $632, $26, and Flint is $150, $548, $02, and those are the numbers that are reflected at the bottom of their columns on Exhibit 42. The point that I'm trying to make here, Your Honor, is that the testimony is that there were no bogey rebates prior to the embassy agreement. And the reason for that is obvious. The bogey rebates are rebates that are specific to embassy based on nationwide sales. So the bogey rebates are brand new. And so what did Michigan Pipe Co. do with the bogey rebates? They folded them back into the company and they paid taxes on them. And that's important because they didn't pay taxes on the rebate. So to kind of go along with this contract is that Michigan Pipe Co. never assumed the ownership of the purchase-based rebates, the vendor breakdown rebates. That they're only taxes will be paid on those when they are distributed, and they are not yet distributed. The non-vendor breakdown rebates that are unique to embassy have not been distributed. They've been incorporated into Michigan Pipe Co. with taxes being paid. Now, to the extent that there was an agreement to pay rebates, the ownership, whether it's an asset of the company or not, is irrelevant. There was an agreement that when these rebates were received, pursuant to the purchases and breakdowns of the vendors, it would be paid out to the respective yards. And we attempted to do that. There's been, particularly with the argument of conversion, there's been arguments that we just withheld the money. Well, the testimony was clear. It took a long time, and it was an arduous task contacting every vendor and coming up with the breakdowns. These vendors really didn't want to do it because it was work that they didn't want to do, and they weren't going to make any money on it. But Justin finally got them to do that, and he finally got the appropriate breakdowns. When they left the company, pursuant to apparently an agreement, even though there was not a buy-sell, when they left the company, they transferred their stock back to the company. And when they transferred their stock back to the company in exchange for money, that's consideration, that's a transaction. So as of the date of that transfer, and we are using for convenience the end of June 2016, Michigan Pipe and Valve, Flint, and Lansing, or to loosely say Nate Bullwinkle and Mike Deneen were no longer shareholders of Michigan Pipe Co. and did not enjoy any of the benefits of Michigan Pipe Co. They no longer could share in the assets of Michigan Pipe Co. They gave up the assets of Michigan Pipe Co. when they transferred their stock back for consideration. With that being said, I'm not arguing that they're not entitled to their rebates that were based on the contracts from 1999 that are based on the breakdowns that we got from the vendor. They're entitled to that, but they're not entitled to company assets that existed. And that's relevant when we talk about management fee. Now, it was a big deal to me, and maybe not to anyone else, but when this case became an at-law case. It's a breach of contract case, and we have a contract that was established in 1989. There's no unjust enrichment. There's no reformation. There's no other implied contract allegations. So I want to encourage the court, and forgive me, Your Honor, because I know you're a business attorney before you were a judge and you've been around, but for the record, I suppose, I just want to encourage us that this is an at-law proceeding and not an equitable proceeding. Had they sued for unjust enrichment, then possibly we could look into this issue of our management fees fair. But the reality of the management fee, the unanimous testimony, including Mr. Deneen and particularly Mr. Bullwinkle, is that those fees were crafted by the board to try to make sure the costs of the company. They weren't particular to a quarter. They were particular to the operation. And one of the problems is the small business, they didn't contemplate people leaving. So the decisions they contemplated were continuity of a business, not having people leave. But they had an obligation. And this obligation to pay management fees has been there since the inception. Since Michigan Pipe Co. was formed, it makes sense because it has to have money. And so that money was an obligation by the individual shareholders. And as Ms. Heath, the CPA, indicated, is that became a accounts receivable. When management fees came in to Michigan Pipe Co., they were income. And when a management fee was invoiced but not came in, it was an accounts receivable. To the individual shareholders, it was an obligation. They agreed that I'm going to be part of Michigan Pipe Co. and I'm going to pay this percentage or this schedule of percentages for my sales. It was a binding contract amongst the shareholders and the board. And there were no other provisions. It was very simple and direct. They did not have a provision that said, okay, but if mine's too high, I get a rebate. No, there was no obligation for rebates. The testimony is consistent that when they had extra money at the end of the year, they would consult their CPA and they would make tax-based decisions. But the point of that is, the board of Michigan Pipe Co. would make a decision for the benefit of the company and ultimately for the benefit of the then existing shareholders. The accounts receivable is an asset of Michigan Pipe Co. When Nate and Bullwinkle and Mike Deneen sold their stock back, they gave up rights to assets to the company. They did not. They're still entitled to their rebates. They gave up rights to other assets of the company. The management fee is a proven contract that based on sales, you pay the percentage. It's that simple. There's no cause of action in this case that would warrant a reformation of that contract or some obligation to reduce it because the owner feels it's not enough money. A comment should be made that you can't base an income summary of any company on 2 quarters, particularly when the first quarter is the winter months. And I think the testimony of Teresa Jaime and Tina Heap, or Christina Heap, went to that. But that's not even the issue because it was a contract they had. Whether it was a good contract or a bad contract is not the point. It was a contract that everyone agreed to, and it's on the books, and they should pay it back. And Mr. Bronco has testified under oath that he's received the invoices. He doesn't want to pay it back because he thinks it was too high, but he never said that it wasn't consistent with the contract that he entered into. And there's no testimony that it was an inappropriate amount given the percentages. The only testimony was that he didn't want to pay the percentages that he had already agreed to pay. In addition to the management fees, there are some related employment fees that were discussed that are on the age receivable. So the two documents that this court needs to come up with the correct judgment is Exhibit 42, that coming up with the appropriate rebate amounts that I've already testified to. I'm not testifying, already stated. And Exhibit 13, the age receivables that indicate that Lansing, and now Nate, owed the company $117,702.18. And by the way, I'll just comment that one of the reasons Nate testified he didn't pay it was because he said, look, why am I going to pay them money when they owe me money? So he had always kind of thought in his mind that this is a set-off. And then Flint had paid its contractual obligatory obligations regarding management fees. And so Flint has just $7,306.01 of unreimbursed costs for Flint's employees. So if you reduce those, we're asking for the judgment just to be the contractual judgment of the rebate amounts that are included on 42 under the column Flint and Lansing, less the accounts receivable amount contained in Exhibit 13. So Lansing is entitled to a judgment of $151,930.08, and Flint is entitled to a judgment of $143,242.01.
Give me your number again for Lansing.
Lansing was 151,930.08. And that is taken the number on 42 less the number on Exhibit 13. And this is based on the fact that there simply was no agreement regarding embassy, the embassy, the rebate, bogey, and sign that were unique to embassy. There were a committee formed of Nate Bowinkle, Mike Deneen, and Linda Prater that never really came up with anything to recommend to the board. And when Justin went back to each individual vendor and came up with the breakdown, the exact process that Linda Prater said was the most accurate process, he came up with the columns that are in 42. The bogey rebates then were just folded back into the company, and then taxes were paid on it. I'd like to comment on retained earnings. I was a little surprised when the retained earnings came up. Retained earnings is an accounting concept that you appear on a balance sheet. Sometimes I refer to it as kind of the, when you add all the assets and liabilities, sometimes it's what's left. But retained earnings is a company concept. It's the books of Michigan Pipe Co. And who owns the retained earnings? And that's the shareholders. And once Nate Bowinkle and Mike Deneen turned their stock back in, they gave up any right to retained earnings. Now, they sold their company assets to Ferguson. And I might be kind of a standard deviation away from Center right now, but their agreement, there's been no testimony that they retained the right to their retained earnings claim. They testified that they retained their right to their rebate claim, but not their retained earnings claim. So in any event, they don't have any right to retain earnings because they gave their stock back. That kind of goes also with the management. CPA Tina Heath testified that management fees were the accounts receivable and income of Michigan Pipe Co. And therefore, it's an asset of the company. And once you turn your stock back in a company, you no longer have rights to its assets. So, therefore, I don't believe retained earnings is a relevant concept in this. And I would submit and agree that if we're going back to 1999 and that there was an agreement, and quite frankly, the testimony is pretty clear that from the inception of Michigan Pipe Co., there have been rebates that Michigan Pipe Co. has entered into, and those rebates were then immediately distributed. When I say immediately, they were ultimately distributed to shareholders. And we have to understand that this company was closely knit group of people, and so they didn't necessarily have the disputes that we're dealing with here. They just went through their year and then counseled with their CPA and made decisions that was best for the company and everyone. But I will submit that it included the contract based on purchases. The most accurate way to do that is vendor calculation, and that's exactly what Justin Jaime did, and that's exactly what's reflected on 42. So thank you, Your Honor.
Thank you. Mr. McCann, you get the last word.
Your Honor, I would just indicate that I think that the retained earnings, actually any offsets that are being requested by counsel should be that the retained earnings would more than cover that. We haven't asked for that in the amount of money that we're asking, but certainly in our chart in Exhibit 39, we've taken into account all of the management fees that were required to make Michigan Pipe whole. And we've done everything to make sure that the correct percentages of my clients' sales, that they cover those management fees and the figures we computed. So we are asking the court to go by our figures in Exhibit 39. Thank you, Judge.
Your Honor, I neglected to mention conversion. May I make a statement on conversion, or?
You may.
Thank you. I just wanted to point out, it's in my brief that I filed at the beginning of the case, but this claim against us is for money. And the case law that I cited indicates that if it's for money, you can't have conversion when you've consented to the defendant receiving the money. In this case, everyone voted on the embassy contract and consented to them paying us the money to begin with. Secondly, in order to have conversion, either common law or statutory, for money, it has to be for a specific dollar amount. And no one knew at any relevant time until this 2018 summary what the specific dollar amounts were. We made offered and pro-offered in good faith, but there was not a specific dollar amount involved. And thirdly, in order to have statutory conversion, you have to have evidence that it was used for the benefit, personal benefit of the defendant. And the testimony is that there was no testimony at all regarding their personal use. So therefore, conversion, in my view, is not applicable in this case. Thank you, Your Honor, for that opportunity.
Thank you. And Mr. McCann, since I let Mr. Miller supplement his argument, I will give you an opportunity to respond since the plaintiff gets the last word.
Thank you, Judge. I believe that the fact that they took the money and applied it to their account as opposed to putting it in escrow means that they did convert it. They converted the personal property of another, exercised dominion and control over it, and therefore I do believe we are entitled to statutory damages for conversion, Judge.
Thank you. So first I want to address the breach of contract claim. I think the evidence establishes conclusively that there was an agreement among the 5 shareholders of Michigan Pipe Company that they would share in vendor rebates in proportion to their purchases from those vendors. In fact, there was a many year course of conduct where that is exactly what happened. The agreement changed slightly when Embassy was brought into the picture, but the agreement that rebates paid by Embassy would be shared in the same manner as vendor rebates were shared previous to Embassy continued. I think that's in fact reflected, so we're not just talking about an oral agreement and a course of conduct. If we look at the board minutes from February of 2016, and particularly the section that discusses Embassy rebates, Linda gave us the fourth quarter breakdown for the Embassy rebates. Just with the fourth quarter rebates, the secret rebates, and the bogey rebates, it was decided that the Embassy group is worth the money of being in the group. Mike Deneen and Nate are going to contact the companies that we received bogey money from so they can get a breakdown per branch. Clearly, that reflects an understanding consistent with their past practice that bogey rebates were going to be shared in the same manner as other rebates were going to be shared. How exactly they were going to calculate that remained a question mark, but clearly the understanding is whatever records we can get to show how that bogey rebate was allocated among the various shareholders is going to be the way in which it was going to be divided. Linda's also working on getting all our quarterly rebates broken down per branch. Clearly, they are going to be allocated per branch in the same manner as it was done earlier, just with the added complication of having having another entity, yet another entity inserted in the chain of events. So we got vendors, we got Embassy, we got Michigan Pipe Company, and then we got the 5 shareholders. It just inserted another step in the process, but it didn't change the agreement. They're going to be shared pro rata based upon our respective sales. And if shipping costs can be pulled out because we can get that information from the suppliers, great. If it can't, then it'll be shared based on sales. The one aspect of the rebates where a separate agreement is indicated, it was decided that because we cannot get a breakdown of the secret rebate, we will pay our dues for the group, which are $10,000, and put the other $11,048.87 towards the Christmas party weekend for next year with our employees. The only rebate that there was any agreement to do anything other than rebate to the individual shareholders was the secret rebate. Now, I find it interesting. They've got a very specific number here. So I gather from this that the secret rebate for 2016 was $21,048.87. I can't tie that immediately to any of the other exhibits, but clearly the people at the table in February of 2016 knew what that number was. It's very specific. So the agreement is that those rebates, both standard rebates, which would be the quarterly and annual and the bogey. And other than with respect to the 2016, well, I guess this would have been the 2015 secret rebate, how that was going to be allocated. But this doesn't reflect an agreement as to what's going to happen with silent rebates after the year of 2015. There's no agreement there. There's nothing. Granted, it's difficult to figure out exactly how that was calculated, but I think the simple way to do that is in the same ratio as the respective purchases of each of the companies contributed to the total purchases by all five. That's the formula that should be used. So clearly there was an agreement as to sharing of rebates and how they would be shared. The rebates have not been paid. Hence, we have a breach of that contract, and what's left for the court to do is calculate what the damages are for that breach of contract. I'm not going to be able to tell you what those damages are today. I started to do a calculation. I have issues both with the calculation that the plaintiffs are proposing, and I have issues with the calculations that the defense is proposing. I think I can figure it out based upon the numbers that I have. So I'm going to supplement my opinion with the specific award of damages and explain to you exactly what I did in calculating those damages. I do not find that the requirements for a conversion claim have been met. This is a contractual dispute. There's been a long-standing dispute as to what the damages are. I would have hoped that this could have been resolved 2 years ago as opposed to waiting until now. But the delay in resolution is something that the statutory interest rate will partially reimburse you for. But I do not find that there was a intent to convert these funds, that there's been a wrongful dominion over the funds. There's been a dispute as to what the amount is. And it's clear that until the correct amount could be determined, it's not unreasonable for the defendant to have withheld payment until that could be resolved. I'm resolving that today. I will make a further ruling as to what the specific damages are, but it's going to take me a little bit of time. I started to do a calculation, but it's going to take me a little while as I compare the respective damage proposals. It frankly looks to me like the plaintiffs have undercounted the gross amount of the damages from the allocation of these rebates. So I plan to use Exhibit 42 with some modifications as to what those amounts will be. Specifically, Exhibit 42 makes no attempt to allocate the bogey or silent rebates. And I know Exhibit 39 does make an attempt to do that. I'm just going to have to compare the two. I can figure out what the total of those rebates are from 42, and I will probably come up with a formula for sharing those that equals how the other rebates were shared. But I think that's a mathematical calculation that I can do from the documents that have been submitted. With respect to the offsets, there definitely was an agreement that the collection of the management fee initially would be according to the sliding scale that's on the one exhibit, and I've lost the number, but you all know which one I'm talking about. But there was similarly an agreement that at the end of the year, if this amount exceeded the operating costs, the management fees, that amount, the overage would be distributed back to the individual shareholders based upon their respective contributions to that amount. I don't see anything that changed that. The difficult thing for me here is the only calculation I've got as to what would be a reasonable amount for that number has been submitted by the plaintiffs. I don't have any calculation by the defendants to go by. But I will be looking at that calculation carefully. I am sympathetic to the fact that there were some ongoing management responsibilities necessitated after Flint and Lansing surrendered their stock, just by virtue of the fact that some of these payments were received well after they surrendered their stock. There certainly is some expense involved in that. I'm going to try to come up with some reasonable way of figuring out what that might have been. And I'm going to have to work from what's been submitted in evidence. But clearly, the $8 million record second quarter sales by Lansing did not obligate them irrevocably to paying $103,000 in management fees for the entire year, based upon the past practice of the parties. So I'm going to have to figure out a way to adjust that. I will, again, take as much time as I need evaluating the numbers, doing my own calculation. I will supplement my opinion with those dollar numbers and explain how they were broken down. And then once I do that, Mr. McCann, you can prepare and submit a judgment consistent with my ruling today as supplemented by my calculation of damages.
I will do that, Your Honor. Thank you very much.
Counsel, I do want to thank both of you. I appreciate it when counsel are respectful to one another, are professional in their dealings, and you've both been very much so. I think both your clients can be pleased with the job that both of you did with what you had to work with. So thank you, and you should be hearing from me, I would guess, no longer than 2 weeks. I should have something out.
Thank you very much.
Thank you, Your Honor.
Thank you. Have a good day, everyone.
You too, Judge.